Between 2018 and 2024, the Western Australian construction sector saw major builder collapses. Subcontractors absorbed financial losses exceeding $1 billion. When a head contractor fails, the subbies lose their money. But when a subbie fails, the builder inherits the cost. They are left with a stranded site and the responsibility for every defect left behind. This liability is codified in the Home Building Contracts Act 1991. Under WA law, the registered builder warrants the structural integrity of the work for 6 years after completion. If a waterproofer skips a step in 2026 and the leak appears in 2031, the builder pays for the rectification. The trade who did the work is long gone. The warranty remains with the license holder. Managing this risk requires a system known as the 5-stage subcontractor lifecycle. It involves determining specific needs, reviewing performance history, establishing strict terms, managing engagement, and evaluating final performance. These 5 stages provide the framework for professional site administration. Every subcontractor selection is a 6-year financial commitment against the builder's own registration. Stage 1 begins before a tender is ever released. Tendering without a formal task analysis is a primary driver of project delays and budget overruns. A proper task analysis breaks a project into specific trade packages. It defines the work sequence, the project timeframe, and the exact quantum of hours required for each task. This analysis also identifies the required technical competence. An electrician working under an electrical worker certificate is not the same as a technician with a specific cabler registration. The final step is documenting a formal subcontractor structure. This establishes reporting lines that give lead trades authority over the trades that follow them in the build sequence. Failing to define these scopes and authority lines at the start leads to inaccurate pricing and site confusion once the work begins. Stage 2 is about due diligence. A builder's goal is to ensure they never rehire a problem by accident. There are 3 mandatory checks. First, the Building and Energy Register. This reveals a practitioner's status, license conditions, and their public disciplinary history. Second, the ASIC Register. This identifies directors with a history of bankrupting companies or engaging in phoenixing activities. Third, the WorkSafe WA Prosecutions Register. This shows whether a subcontractor has been convicted of safety breaches or had serious incidents on their previous sites. This information forms the basis of a per-subbie management plan. Known weaknesses, like poor paperwork, can be mitigated with specific contractual hold points. These 3 database searches take 10 minutes. They are the most efficient way to identify risks before a subcontractor is invited to tender. Stage 3 establishes the contract. In Western Australia, every subcontract now exists within a fast-tracked statutory adjudication regime. Under the SOAP Act 2021, a subbie serves a payment claim. The builder has a fixed window, typically 20 business days, to respond. If the builder misses that deadline, they legally owe the full amount. There is no defense available. Disputed claims move to binding adjudication, where a decision is typically reached in about 3 weeks. Builders must also consider the Australian consumer law. The unfair contract terms regime now covers small business subcontracts with fewer than 100 employees or under $10 million in turnover. Penalties for enforcing an unfair term, like a unilateral right to terminate without cause, reach up to $50 million for corporations. Using outdated bespoke contracts or simply ignoring payment schedules can quickly drain a head contractor's entire capital reserves. Stage 4 involves the final selection. This covers baseline requirements like equal opportunity compliance, capacity checks, and safety inductions. During this stage, builders often rely on a major industry misconception: the idea that the 80% rule defines whether someone is an independent contractor. The 80% rule is an ATO tax test for personal services income, determining taxation and deductions. It has no connection to employment law. For employment status, the Fair Work Ombudsman uses the Section 15AA Whole of Relationship test, examining the practical reality. The test asks, who provides tools? Who sets the work hours? Can the worker legally subcontract? If the relationship functions like employment, calling the worker a subbie is sham contracting. Current penalties for sham contracting are up to $93,900 for individuals and $469,500 for corporations per breach, plus the back payment of all leave and superannuation. Relying on an ATO tax rule to defend against a Fair Work prosecution is a legal failure that often results in bankruptcy. Stage 5 is performance evaluation, requiring tracking against 4 KPIs: time, cost, quality, and conduct. To ensure accuracy, builders triangulate 6 sources of information, ranging from site diaries and project manager data to direct observation of other sites. When a subcontractor underperforms, the builder follows a documented sequence: a verbal warning, a written warning, a show cause notice, and then contractual remedies. Skipping steps in this pathway invites legal challenges from the subcontractor. Maintaining a fair, documented review process is the primary defense against retaliatory security of payment claims or discrimination complaints. These 5 stages provide a comprehensive system for project oversight. This management cycle is a core requirement of the Building Services Registration Act 2011. Under this act, inadequate supervision of a subcontractor is a direct disciplinary failure for the head builder. The Building Services Board can suspend or cancel a builder's registration based on the failures of the trades they engage. In Western Australia, disciplinary records are public and permanent. A builder cannot shift the blame to a subcontractor. Rigorous management across the 5-stage life cycle is the non-negotiable cost of holding a WA builder's registration.